We back with another video, y'all, and I want to give y'all an update on the situation I got going on. Now, this is one of my cases right here, and I've been making videos about this. And this situation happened January 28th of 2023, y'all. Officer came on my property and took my truck, like I was telling y'all, to go to Crimmins, South Bend Police Department. Before I get going, I want to say that this is for educational purposes only, and it's also for informational purposes only. And this video is also for who it pertains to, you dig? And the situation I'm telling y'all, it wasn't an isolated incident. This was a retaliatory incident that stemmed from me fighting my prior conviction. When I was telling y'all about the cop who committed perjury, I should say, and the judge who used racial discrimination and all that shit. So yeah, this situation stemmed from that. And my whole family gets woken up by Dakota Crimmins. Pops up here, banging on my doors, banging on my windows of my home. I look outside, he's snatching plates off my truck. So I'm like, what the fuck is going on? I go outside and I'm like, dude, what are you doing here? Who called you here? He's like, oh, well, the plates on your truck are stolen. And I'm like, what? He's like, yeah, the truck's not showing that it belongs to you either. And so the first thing off the dribble where I attacked at was in my claim to as well. I stated how could he assert any knowledge of ownership if he didn't know who I was? And that's in the police report. I don't got the police report right now. I'm gonna show you on another video, but yeah, that was one of the first things he told me when I came outside my house. He was like, yeah, and the truck's showing that the truck's coming back, that it's not showing, that you own it. And I'm like, you ain't asked me for no ID or nothing. Like, how the fuck do you even know who I am? Bingo. So, anywho, this is a response from the judge. I just got back recently. Let's check the date on that. That's 12/11/2025. Read to y'all what they saying. This says order for written status report. It says Federal Rule of Civil Procedure 16B requires this court to enter a scheduling order after consultation with the parties, fixing deadlines for amendments to the pleadings, the commencement and completion of discovery, and the filing of dispositive motions. As a result, this court orders the unrepresented prisoner, plaintiff, and the defendants to each separately prepare and file a brief status report, not to exceed 3 pages unless greater length is unavoidable by January 12th, 2026, y'all. And we already did that, got that sent in. We actually waiting on them to respond. The parties' reports should address 1. The nature of the case and the principal factual and legal issues. 2. Whether all parties have been served or any parties dismissed. 3. The discovery each party intends to undertake. The anticipated time necessary for completion of discovery, and any limitations on discovery that any party believes may be necessary. It says 4. The time within which amendments to the pleadings shall be allowed. 5. Motions now pending or anticipated by any party, and the status of any briefing remaining related to any pending motions. 6. What deadline should be set for the filing of dispositive motions. 7. Whether any aspects of the case have been stipulated or settled, and when the parties expect to complete mediation or other alternative dispute resolution efforts. 8. Whether the parties have considered litigating this matter under this court's consent procedure as explained in the 2-page consent form issued contemporaneously with this order. Upon receipt of the parties' ordered status reports, this court may schedule a preliminary pretrial conference before entering, pursuant to Federal Rules of Civil Procedure 16B, y'all. And it says, in the meantime, plaintiff is advised that his pro se status does not relieve him from compliance with the federal rules of civil procedure and all orders of this court. Shot some case law at me. Katie versus Sheehan, consistent with the mandate of Federal Rules of Civil Procedure 1 to secure a just, speedy, and inexpensive resolution of this action. Pro se parties are held to the same procedural standards applied to parties represented by counsel. Strict compliance with court orders is also expected, and failure to comply with the court orders may result in sanctions up to and including dismissal of the case. See Federal Rules of Civil Procedure 37B, 41B, Dreedy versus AM Fam Mute. Yep, they hit me with more case law, y'all. The clerk is directed to send consent forms to all parties along with this order. And that was December 11, 2025. This is by Scott Frankel, y'all, in which I have two judges writing me. But I want to show y'all something else. So, and this is the thing right here, y'all. So, Damon R. Leahy was on my first lawsuit that I filed on the carrying a handgun without a license with the officer who committed perjury. He already had knowledge of that, right? So I was handing it to him in the paperwork. He transferred the case to Crystal C. Briscoe, a judge of dark skin, who took it upon herself to also engage in this conspiracy and dismiss my claim. You see what I'm saying? So like I said, this shit rolled around. He jumps on this case too. Now he's trying to get me to transfer my case to a magistrate. Now let's look at this real quick. This is what they sent me along with this order. I got another order too from the other order is from Damon R. Leahy. He's basically striking my filings and telling me the same thing that Scott Frankel was saying that, hey, you're held to the same federal standards as, you know, someone who's represented by counsel and all that bullshit. So check this out. This is notice of availability of a United States magistrate judge and fast track litigation for cases with a pro se litigant. Look at this. Now remember I just told y'all Damon R. Leahy was on the first case. He transferred it to another judge. Now he's on this case. He wants me to transfer it to a United States magistrate. So let's read this. If all parties agree, the assigned United States magistrate judge will preside over the entire case from discovery and pretrial matters through trial. A magistrate judge can bring this civil case to trial faster than a district judge because magistrate judges do not preside over criminal cases. If you want the assigned magistrate judge to preside over this case under 28 U.S.C. 636C, Federal Rules of Civil Procedure 73, and the court's general orders regarding the assignment of cases, select the first option on the attached consent form. Also, if all parties agree, the magistrate judge will hold a bench trial within 6 months of the date of full consent. This fast-track litigation program requires all parties to 1. Waive the right to a jury trial, 2. Limit discovery, and 3. Waive the right to file a summary judgment motion. This is why it's good to fucking read, bro, and not just put your signature on shit. The amount of discovery will be determined by the court based on the requirements of the case. Normally, this will be 1 deposition, 5 requests for documents, and 15 interrogatories. If you agree to the requirements of the fast-track litigation, select the second option on the attached consent form. And come on, man, we decline, bro. Why would I do that? You see what I'm saying? Why would I switch my case to a fucking magistrate and waive the right to file a summary judgment, waive the right to a jury trial? This is fucking trickery, and this is what happens when you don't read, bro. So like I said, I'm just showing y'all this is what's going on right now with that situation. I got the defendant's status report. Look at this, y'all. They are asking for 10 months of discovery. Defendants believe that deadline of October 30th, 2026 to complete discovery will be appropriate. They trying to take it all the way to December 4th, 2026.